Order in the court. Be seated.
It's time for Talk Law Radio with Todd Marquardt. Todd Marquardt, attorney at law in Texas. If you're a millionaire or a thousandaire, Talk Law Radio is now on the air. Call in with your business law question, your elder law question, veteran aid, Medicaid, build a business to get paid. 210-308-8867. Or ask a question online at marquardtlawfirm.com. That's MARQUARDT lawfirm.com. And now it's Talk Law Radio with Todd Marquardt.
Listen up to discover your legal issue blind spots by listening to me talk about the law on the radio, podcasts, Facebook Live, YouTube, and talklawradio.com. Today we're going to be talking about probate law in Texas. And I'll begin with, what is probate? Probate can be a specialized court in Texas that hears cases relating to decedents' estates and wills, and even people without wills sometimes have to go through the probate process. So it's a specialized court, but it's also a process. So attorneys that practice probate law will sometimes refer to probate as an area of practice, the type of court, or the process by which you transfer title from a deceased person to the living heirs or the living beneficiaries of a will. So the reason I got into this is because when I was very young, my mom's dad, my gran, he passed away when he was about 60 years old. He died of pancreatic cancer. And he had a will, and I didn't really know what that was at that time, but he had all his legal affairs in order. But there were some things that he didn't have yet wrapped up because it was sort of a surprise that he passed away. But I'll ask you one question. Finish the sentence for me. In this world, nothing can be said to be certain except death and taxes. So what things have to be done when somebody passes away? By the way, who said that quote? That's right, Benjamin Franklin. So what must be done upon death? Well, if you discover that someone you know or love, or even somebody you don't know, has passed away, you either call the funeral home, or if they pass away under suspicious circumstances, you call the police. Then you attend the funeral. But if you have a friend or family member that's supposed to be at the funeral but isn't at the funeral, there may be a problem. They may be back at the deceased person's home cleaning it out, taking all the stuff. So you probably want to make sure that that house or that property is secured. Might have to change the locks, or get an alarm system installed, or hire a security guard to stand on the porch. So then you have to pay for the funeral, because the funeral home isn't going to do that for free. And the deceased person might have life insurance, or they might have money in the bank, or you might have to spend your own money and ask for reimbursement later. Then you'll want to call an attorney and ask about probate. By the way, this episode is sponsored by Marquardt Law Firm. They focus on business and estate law, including last wills, living trusts, and tax-protected inheritance plans. And when you call Marquardt Law Firm because you have questions about probate, one of the attorneys there will schedule a time to talk to you or meet with you, and they're going to ask you a bunch of questions about the will, or if there's no will, about the family, and they'll ask you what kind of problems you're having transferring property from the deceased person's name to the heirs or the beneficiaries, and that'll help the attorney understand what kind of probate there is. I'm going to talk about that in just a couple of minutes, about all the different kinds of probate. Then, after somebody has authority to manage the estate, take care of the deceased person's affairs, that person could be the personal representative, it could be the executor, it could be the administrator of the estate. It's all essentially the same duty to collect what's owed to the deceased person and what we call marshal the assets. That means you're going to try and locate all the assets, the bank accounts, the properties, automobiles, the personal effects, and take control of it and protect it and make sure that it doesn't lose value. Make sure it's insured. Then, whoever's in charge of the estate, the executor or the administrator, is going to pay the bills, whatever the deceased person owed. And it gets a little tricky there, so there's procedures in place to help the executor know what bills to pay and in what order. So if you have questions about that, you definitely need to talk to your favorite attorney. Then, after all the bills are paid and all the stuff is done, then the executor or administrator of the estate will probably distribute whatever's left to the beneficiaries or the heirs. By the way, this isn't legal advice addressed to your specific circumstances, because I don't know your specific circumstances, but this is just general information. You should contact an attorney that you know, like, and trust to get specific advice about what you should do. Here's another question. What two things have to happen in order for a last will and testament to be useful? Okay, well, I'll tell you. Number one, you have to die. The last will and testament is only useful after a person has died, because if you're still alive, then it can still be changed and it doesn't really have any effect. What's number two? Well, you may have guessed that a judge has to look at it and approve it and determine that it is a valid will. And you're probably asking, why does a judge have to look at it and decide that it's a valid will? Because some wills are not valid. There's a statistic out there that shows that some wills, 7% maybe, are invalid. And another statistic says that maybe 9% of wills out there are invalid. You know who had the most famous valid, invalid probate process? Famous person, famous airline test pilot, and film producer. Howard Hughes. Remember that movie that Leonardo DiCaprio played Howard Hughes? That was a good movie. I didn't really know Howard Hughes before that movie because I'm just a young person. But it was said, it's rumored, that in his later years in life, he wouldn't carry a wallet or any money. And if he needed to pay you for something, he would take out a scrap of paper and write a will and name you as a beneficiary. So here's what really happened. I don't know whether that was true or not, but he did have a lot of wills, or at least a lot of people introduced wills purported to be signed by him in his probate. His estate was in the probate process for 34 years, from 1976 to 2010. According to the Wall Street Journal, around 1,000 people have benefited from his estate, including 200 of Howard Hughes's distant relatives. And after liquidating his estate, they were awarded about $1.5 billion. So there was a dispute about whether he was married at the time he passed away, and there was a dispute about whether he had a child. That's why we have to go through probate. The word probate comes from the Latin word probare, which means to test or prove. It's usually used for wills. It can be applied to other legal documents, as in proving the validity of a document or official certification proving the document is real. I said that I would mention the different types of probate proceedings. In Texas, Estates Code Section 22.029, the words probate matter, probate proceedings, proceeding in probate, and proceedings for probate essentially are synonymous and include a matter or proceeding relating to a decedent's estate. And what could that be? What is a probate proceeding? The probate of a will with or without administration of the estate, the issuance of letters testamentary and of administration, an heirship determination or small estate affidavit, community property administration and homestead, an application, petition, motion, or action regarding the probate of a will or an estate administration, including a claim for money owed by the decedent. It could be a claim arising from an estate administration and any action brought on the claim. The settling of a personal representative's account of an estate and any other matter related to settlement, partition, or distribution of an estate, and a will construction suit. So now I would like to talk more specifically about some of these ways of going through probate, because probate is really a spectrum of different things. There can be easy, simple probate. There can be difficult probate. And generally, there can be independent probate or dependent probate, unsupervised probate or supervised probate. The first thing we'll talk about is ancillary probate. This is the type of probate you have when you've already been through probate and you have to go somewhere else to go through probate again. So why do you think that would happen? Well, it's because you might have real estate in different countries or even different states within the United States. The law of probate is a state law, and the different states have different ways of going through probate. And so if the deceased person lived in Texas but had a ranch or a vacation home in New Mexico, might have to probate his will in Texas and then do ancillary probate in New Mexico, or vice versa. So because state law controls probate, real estate located in New Mexico is subject to New Mexico probate law. Real estate in Texas is subject to Texas probate law. The next type of probate I'll talk about is temporary administration. That's a funny word, temporary, because what it really means is emergency probate. And it also happens to have an expiration date, which is why they call it temporary. Here are a few examples of when you might decide or think that you need temporary emergency probate. Number one, a will contest has broken out, and disputing potential beneficiaries want to secure the deceased person's assets and property. Again, if somebody's not at the funeral, they might be cleaning out the house. So you need to maybe become temporary administrator so that you can have legal authority to change the locks, buy the alarm system, and post the security guard on the front porch. Another one is maybe the deceased person had a business and maybe the business is going to suffer and lose value because nobody's running the business. You can have a temporary administrator appointed to run that business so that it doesn't lose value. Another one would be a lawsuit must be filed within time limits, within the statute of limitations, and you have to have a temporary administrator appointed because you need to get this lawsuit filed immediately or you need to get an answer filed immediately. Next, we'll talk about probating the will as a muniment of title. That word muniment is strange. I've never heard it anywhere else outside of this context. What it means is you can have the will to serve as a link in the chain of title. It serves only that purpose. No administrator is appointed. There's no executor. There's no administration of the estate. The will simply serves as knowledge of how property was transferred from the deceased person to the beneficiaries in the will. Sometimes we use this procedure when 4 years have elapsed since the person died. If there's a 4-year statute of limitations on probate in Texas, and sometimes the executor named in the will doesn't think they have to do anything, and so they neglect their duty, and the expiration passes, the statute of limitations passes, and somebody later finds out that title to the real estate is clouded, meaning that the title company doesn't know who owns the property because the will was never probated. Well, if the executor is not at fault for neglecting his duty, then he might be able to file the will as a muniment of title. If you really need to know, call an attorney. Can't give you legal advice about whether you need that or not. Not in this radio show anyway. Okay, next, I'm going to talk about independent administration. This is the unsupervised type. This is where once the judge appoints the executor or the administrator, the judge is not going to follow up to see that he or she has done everything that needs to be done. That's why it's unsupervised. Now, beneficiaries or heirs can complain later that something was done inappropriately or incorrectly, and so it's essential that this administrator or executor have an attorney that's guiding them through the process, because the executor or administrator has fiduciary duties to act in the best interest of the beneficiaries or heirs. Okay, so I talked a little bit about the process of what that court procedure looks like. I don't have that much time to talk about it right now because I want to talk about what happens if you have a will, but the people nominated to be executor are either deceased, ill, unable to act for some reason, or just plain declined to serve. They don't want the job. Well, somebody with standing can still apply to the probate court to be named administrator of the estate. It's a slightly different process because the court and the law says that the deceased person didn't choose you, so we don't know if you're a trusted person or not. And this is where there's different ways of getting through it. If you can get the consent of all the beneficiaries of the will to agree that you should serve unsupervised and without bond, then the court will grant that. If you cannot get everybody to agree, then it would be like a dependent administration, a supervised administration with a will annexed, meaning that there's a will, we're going to follow the will, but the person applying to be administrator of the estate is going to be supervised and is going to have to post a bond. Okay, then I want to talk about intestate. Intestate is a legal word that means the deceased person died without having a will. And the person applying to administer this estate can act independently and unsupervised if all of the heirs agree. Now, who are the heirs is a little tricky to figure out. You may think you know who the heirs are, but now you have to prove it in a lawsuit down at the courthouse. So you have to have testimony and evidence, and the court is going to have to appoint another attorney, what they call the attorney ad litem, to double check your work and investigate the facts and represent the unknown heirs. And just find out if there's anybody that was possibly forgotten, left out, or the black sheep of the family. So if you cannot get all of the heirs to agree that you should be the independent administrator of an intestate administration, then of course you can still apply, but you're going to have to post a bond and be supervised by the court. This is what they call a full-scale administration. When you're supervised by the court under a dependent probate, you have to get permission from the court to do everything. You have to get permission by the court to receive assets, to marshal the assets, to spend money on expenses. You have to get permission from the court to approve of your accounting and inventory of the estate. And you also have to get permission if you want to sell property or if you want to distribute assets to the beneficiaries. And so you can probably imagine that because you need the court supervision, it's going to be expensive. There's going to be filing fees, appraisal fees, there's going to be attorney's fees, because they're going to have to file all of these pleadings to get permission and possibly attend hearings to get permission so that the administrator of the estate can follow through with everything. There's another thing that people think is so easy called small estate affidavit. And if there are debts less than the value of the assets in the estate, and the person died without a will, and the assets are less than $75,000, theoretically, somebody could file a small estate affidavit and collect the assets of the estate and have them distributed to the beneficiaries. But judges and courts hate the small estate affidavit because people think it's so easy. They make a lot of mistakes and take up the court's time in reviewing and evaluating these small estate affidavits. So they would much rather you file an application for probate than file a small estate affidavit. It's very difficult to get these approved because the court scrutinizes them so much. Why? Because people make so many mistakes because they think it's so easy. I just cannot emphasize that enough. If you find an attorney that agrees to do this for very little money, you should run far, far away because it's not going to be as easy as you or the attorney thinks it is. Remember when I talked about proving who the heirs are? Well, if you die without a written and signed last will and testament, the state of Texas will write one for you. And you might not be happy with who's going to get your things. And it's all very complicated about who would be your heir, entitled to a share of your estate. And so I'll just tell you some of the factors that are considered in deciding who's going to benefit from your estate if you don't have a last will and testament. Number one, it depends on whether you have community property or separate property. Number two, depends on whether you're married or not married. Number three, depends on whether you have children or no children. And then it depends on who the other person was that you had children with. So if you have multiple marriages or relationships and children from different partners or spouses or whatever, it's going to get very complicated. And we hope that you like fractions because that's how things are going to be divided. The best thing that you can do, and this is just general information, is to go to a lawyer and ask about a last will and testament. And you're probably thinking, but I don't need a lawyer to write a last will and testament. Well, your decision about that is legal advice that you're giving yourself. And so you might want to double check with somebody that has been through this a time or two. I've been doing this, I think, for 17 going on 18 years, and I've seen lots of problems with wills. I've seen wills written by attorneys that were bad. So I wouldn't just say go to any attorney. I would say go to an attorney that has been writing wills for many years and that has been through probate many, many times, because we learn what all the problems are with wills by practicing in probate court. And we learn how to write good wills by practicing in probate court. So that's always good to have an experienced attorney. Well, I think that's it for today. I've got to wrap up, but I enjoyed talking to you about probate. Remember to go to YouTube and subscribe, and I'll talk to you later. Thanks.